The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
Right? And that's why I'm just trying to map this out here so you guys can kind of see the assignor, the assignee. If we do that, which will tell you which defenses are good, because they'll say, okay, these defenses are good, because they're just what then? An assignee. Do you see where we're going? Here though, now we said suppose Farmer Fred signs a negotiable promissory note for $153,000. So now here, instead of this was our contract. Now we're going to say, let's take a promissory note. And now Farmer says, here you go, to get this is going to be a promissory note that I'm giving you. He still got the tractor in exchange for it probably, right? But now what does John do? He takes this promissory note and he does what? He transfers it to who? Finance. Finance is giving him something in exchange for this note. In a way there. So he transfers that negotiable instrument. Do you see where we're going? But now who's going to get this? He now has limited defenses because they're now what? A holder. Yeah. You know, and then we get the same thing here. Suppose now that they have a roofing company replace the roof on his home, he signs a negotiable promissory note for $5,000 to the roofing company, and then that roofing company transfers it over there. And we'll get into the holder in due course, like again, the holder there. So you kind of get to see, we say assignees, ordinary holders, they have certain defenses, but the holder in due course get greater. And hopefully, I mean, if you go back to the charts, hopefully that helps. I just wanted to realize when you're looking at like contract rights, that's what we're doing. Take your real contract and then bring in that third party to show there. Questions on that so far? All right, let's look at another one, example. And I'm going to do a few more examples. As we look at parties too. I'll move this guy up. I'm going to use Sam Shyster for a moment. So let's talk about Sam. All right, what does Sam do? Sam purchases a computer from Henry Honest for $650. So you have Sam Shyster and Henry Honest. And what does he do? For $650, he purchases this computer. So he sells the computer. He gives him the money of $650. Okay? But when he gives him this money, he writes it in a check. So we have a what? Negotiable instrument, right? Because it's a check for $650. Who is Henry? Identify the party. Henry gets a check. What is he? He's a holder. Right? He's the holder because he has the check. He's the instrument of that check. All right. Let's do Sam Shyster. He purchases the computer from Henry for $650. Sam now assigns his right to the payment. Right? So he hasn't given him anything yet. He purchased the computer for $650. And now what does Sam do? We know he now takes it and he assigns the right over to Fred. So he says, actually, let me draw it this way. I gotta stop using my hand. Let's do it this way. Because instead of saying, pay me, he says what? Don't pay me, but pay Fred the what? $650. You see where we're going? Yeah. Here, he assigned. Let's identify the party there then. Who is Henry? Who is Fred?
Fred is the assigner.
Yep, Fred's the assignee. And who's Henry then? The assignor. Do you see where we're going? Because he assigned that right to payment. So far you notice the difference between the two? One is he gave him a check. He's the holder because he got a check for this. Here he still owes him money, but he purchased this computer for $650. He hasn't paid him yet on it. But what did he do? He took it and said, hey, because these two had some sort of transaction or something, he said, I'm going to give you my right to payment. And therefore he assigned his contract rights to payment to him. he now becomes the assignee, he becomes the assigner. Let me do one more. Sam purchases a computer from Henry for $650. Sam gives Henry a check in the manner of $650. So same thing here, I'll just redraw it. Okay, he purchases the computer, but he gives them the instrument of a check for $650. Okay. Now, Henry takes the check and he transfers it to Fred. So now he takes this check and he gives it to Fred. Okay, and we can even say he gave value, whatever it is, for that. Identify the parties. Who is Henry? What was he originally in this transaction?
Holder.
Okay. Once he transferred it over to Fred, who is Fred? What?
Holder.
Just a holder?
Due course.
Holder in due course.
Wait, why would he be?
I had him give value.
Oh, and the value is one of the constituents.
Yeah. Just so you guys knew where it was going.
That makes sense.
Yeah. So he became, when he transferred it further, right, he gave value. We're going to do the other elements, good faith, because we'll talk about what makes you a holder in due course.
So what does the value, like, what is the constituent of value in terms of holder?
Value is similar to consideration in contracts. Remember how you had to give something a value, whether it was payment of money, services, things like that?
Yeah,
We're going
so-
to give value, and you're going to do it in good faith without any knowledge of any wrongdoing. And that's what we're going to get into
Yeah,
now
okay.
is how do we become a holder in due course? So how do we become this holder in due course? In order to become a holder in due course, you have to meet certain elements, right? You have to establish this. So first off, we have to give value for the instrument. I'll just put HDC up there. So for holder in due course, we had to give value for the instrument. You have to act in good faith. Okay? And you have to have no knowledge. You do not have any knowledge of any defenses or adverse claims. So no knowledge. Of adverse defenses or claim.
What does that mean? No
It's
knowledge.
you don't know of any wrongdoing.
Okay.
So like when he gave him the check for $650, maybe he didn't have funds in his account and wrote a bad check, but he had no knowledge of that. He thought it was still what? A good check, transferred it over the next day or that day, later that day. Do you get where we're going? He has no idea that this check is going to bounce. Do you see where we're going?
Yeah.
And when he gave value for it, he didn't know of this wrongdoing.
Okay.
But let's say he knew that in order for him to obtain the computer, he gave a bad check and was in on it. Do you see where we're going? Then he can't be a holder in due course because he knew of the what? Wrongdoing.
Okay.
He knew why he gave him a bad check in order to get the computer. He would have that no knowledge of the wrongdoing.
Okay, so then he couldn't be a holder in due course.
Correct.
Okay.
Because that's the whole thing is we can establish, and we'll go through each of the elements again, okay? You know, so any of the adverse claims and defenses. So do that. And we'll go through this because if you can negate one of these elements, they can't be of what then? A holder in due course.
Okay.
Remember, like for negotiable instruments, if you can negate the negotiable, and really fast, this is a detour. I am not trying to do a statement. I am not trying to be mean to anybody, and this is not meaning anything. When I got to work today, I learned that half of it somehow I never felt chipped off of my nail coloring, and it broke the nail to right there. And when I went to go file the nail, it ripped the rest of the coloring off. So, and I had no nail polish in my office to paint it a color at least. So that is not a statement. Just don't think I'm flipping you guys off or anything with that. All right, so let's talk about our elements then. Let's start with value. What is value? Value can be established in one of three ways. Okay? You can, I'm like, where's my little textbook? The value, we said, can be established in one of three ways. So you can be a holder who promised to do something in exchange. You can be a transferee who takes the instrument as security for a loan. Because maybe you borrowed some, like, you know, you gave someone money and they gave you this then as loan to order to get the money from it. Or what could happen is you could transfer, the transferee receives the instrument as payment for a debt that was already owed. Hey, I owe you money, so here I'm going to give you this to pay off the debt. So let's say when he got this $650 and transferred it, maybe because he already owed him $650 and said, here, I got a check for $650, I'll just transfer it what? To you to satisfy my debt that I already pay you. I'll give you the negotiable instrument. Instead of me cashing it, I'll just give it to you, you cash it, now we're even type thing there. What is good faith? This is where the holder acquires the instrument with no knowledge of any defects, I said, or any wrongdoing. Bad faith can exist if one acquires the instruments under odd circumstances. I know your textbook did one and said, let's say somebody goes and purchases the negotiable instrument at midnight in a bar. That might look a little shady, like, why are you doing this transaction at midnight in a bar? Do you know what I mean? Or something like that. They might look at that. Or if it's an odd circumstance, something that might raise a little shadiness, like, that sounds a little strange. Why'd you do that? They might say that there's no good faith. Okay, that there's some bad faith existing there. If there appears to be a close relationship between the parties, then circumstantial evidence could establish the notice of a problem with that instrument. Okay, and they'll call that a close connection doctrine. So let's look at another example, and I'm going to stick with Sam Shyster for a minute, and we're going to stick with Henry Honest. Okay, so Sam Shyster purchases the computer from Henry for $650, and I'm just going to redraw it just to kind of help. Okay, computer, $650, and we have Henry. All right. Sam gives Henry a check in the amount of $650, so this was a check. Henry takes the check, he signs it, and he transfers it to Fred. Right? So this kind of now goes where? That check to him. If you want to look at it that way, however he takes it and transfers it there. Neither Sam nor Fred knew neither Henry nor Fred knew that Sam did not have the money to cover the check. Which kind of is going back to what? When you were asking me something, right? The adverse claim, the wrongful doing. So neither. So let's identify the parties, though. Who's Henry?
His friend.
He's the holder, right? Because he was the one who was given the check. He became the holder initially. Who's Fred?
Holder in due course.
Right. He's the holder in due course. Would it make a difference had Fred known of the check being a bad check?
Yeah, he wouldn't be able to receive those rights.
Right. Because then we would negate the good faith, and he had knowledge of any wrongdoing, right? That he had that. So that could make a difference there. So if he knew even that he wrote it with insufficient funds, anything like that, or maybe he knew he was, I don't want to say imposter, but maybe he knew he forged, or do you get where I'm going? Like, oh, that's not really Sam who gave him the check, that was so-and-so.
So that would make Fred not owed that money?
Can he be a holder in due course?
No, but what does that stop him from
What
getting?
it just means is he's not a holder in due course on this instrument. Let's say he took it in exchange for money that he owed him, but if he knew of the wrongdoing, he can't go after him for payment on that check because he's not a holder in due course.
Okay.
Do you get where I'm going? If he knew of
Yeah.
the wrongdoing.
Yeah.
Now you can become a holder through a holder in due course, though. But we'll get to that in a minute further. Do you get where I'm going? But what we're saying is, remember I said there's 3 ways we could get value. One could be it satisfying the debt. If he already owed him $650, but all of a sudden he gets this check and says, oh, here, I have a check for $650, I'll give this to you to satisfy my debt, does he still owe him $650?
Yeah.
Yeah, because under his original debt, he owed what, $650?
Yeah.
It's just this check now isn't good here, maybe, because he didn't take it in good faith, because he was aware of the wrongdoing when he obtained that check.
Right. Okay.
You know what I'm saying? That's not going to necessarily mean he can't collect on his original debt. It's just when we get to this negotiable instrument, he's not a holder in due course for that purpose.
Okay.
Yeah. Is everybody with me so far on that? Okay. An instrument can be negotiated after it has been dishonored. overdue or was an outstanding check. However, this could raise suspicion that there's an adverse claim or defense. So if the party actually obtained the instrument with any knowledge of any wrongdoing or any defenses or any adverse claims, what will happen here is the party cannot be a holder in due course. It's possible, though, I said, for the party to become a holder in due course by taking an instrument from a holder in due course. Do you get what I mean? I remember I said you could then, and you looked and I said, hold on, we're getting there, a holder through a holder in due course. You can become then somebody who gets a shelter rule protection because you might lose the status of being a holder in due course, but because maybe you acquired it from a holder in due course, do you see where we're going? You now became a holder through a holder in due course.
So do those holder in due course protections apply if you become a holder through a holder in due course?
Mm-hmm.
Okay.
And what it might be is now all of a sudden you became the holder, you negotiated further through to Brad, and Brad was not a holder, he's a holder through due course, right? He obtained in good faith, but now all of a sudden Brad gives it to Tanisha as a present.
Okay.
I'm going to gift you $1,000 because I have a check for $1,000, but she didn't pay any value. She got it as what?
A gift.
A gift. She can't be a holder in due course, right? Because she didn't pay anything, but she might become a holder through a holder in due course. And do you know what I mean? So then she might get rights through him.
So she didn't assign any value, but because him and I, transferred everything.
And I have examples we'll look at. Hopefully will help you guys. And I use some promissory notes too. So I'll do one with a note, one with a check and stuff like that. So when I said it is possible for a party to become a holder in due course by taking an instrument from a holder in due course, and I was up to the shelter rule. So under a shelter rule, persons who are not a holder in due course are given the shelter of the status of the holder in due course. So they're really like a holder, and then they're a holder through a holder in due course, I guess as you would say it, and that whoever transferred that instrument to them. So for example, your favorite aunt received a note, okay, in the amount of $1,000. She received it as a holder in due course. The note is due on November 1st, okay, 2015. Your aunt is well off. She really doesn't need the money. So, okay, you have aunt, right? I'm just going to call it Bobby. Bobby gave aunt a note for $1,000. We said she acquired this note and became what? Holder in due course. She's well off. She doesn't need it. What does she do? She transfers it over to you. And she gives it to you as a graduation present. I don't need this. Here's your grad present. I'm giving you this note for $1,000. And it's your grad present. Okay? And that's what we're talking about here. And she gives it to you on December because you graduated in the fall semester, right? You now have become a holder because you have what? The note. But you're not necessarily a holder in due course because you never gave what? That value, right? Those three forms of value that we said. So here, even though you didn't satisfy all the elements for a holder in due course, the shelter rule what they're going to do is that's going to turn you into a holder through a holder in due course. Because you've now gotten the instrument, and even though you didn't give anything, you didn't meet all those elements, we're going to turn you into a holder through a holder in due course, which means you'll get what? The shelter of that rule to kind of help you out there. I got Helen. Let me hold these because these are a little bit longer. Helen executes a promissory note. Payable to the order of Paris. Helen did not pay the note when it was due. And Paris brought suit on the note, producing it in court. So she gives him a note, it's payable to him. She doesn't pay it. He now files a lawsuit against her for not paying. Okay, and he produces the note in court. Helen admits that she had signed the note, but she claims Paris was required to prove that the note had been issued for consideration and that plaintiff, Paris, the one who's suing, was in fact the holder. And my question for you are these elements of proof required as part of the case? So Helen had issued a promissory note to Paris that was payable to Paris. Okay, it was payable to the order of Paris, right? Helen does not pay the note when it's due. So let's just say it was due by today. She doesn't pay it. He subsequently turns around and sues her on this note. And he produces the actual note to the court. He shows them what she gave him. And Helen admits that, yes, I signed it, but you're required to prove that what? It had been issued for you for the consideration, for the value. And that you have to show that you are a holder. Is she correct?
Yes.
Yeah, I
Why?
would think so.
Why do you say?
Because they have to make sure that Paris had value for the promissory note, right? There had to be so to receive the promissory note, there's still a value that's due for that, correct?
Well, I'm going to let others answer too, because I want to hear. You said yes, and I know you said yes. Sam, yours,
I mean,
Abby.
it was pretty much the same thing as she said. There has to be some like value.
And don't forget, we're doing promissory notes right now, so they probably gave money. They did borrow. Because the promissory note is, I'm promising to pay you back money at such and such interest within so many days. So is it a debt that she kind of owes?
Yes.
Okay. You are.
I would say that she has to like add value on her end because like the standard that value creates is kind of how that Helen has to have something of value to give Paris in exchange for the promissory note. There's something that she has to do.
Well, let me ask you this. Who has the note?
Paris.
Does he have to prove anything else? What's usually the rule? Who's ever the what?
In possession.
The holder of the instrument, right?
Yeah.
Who's got the instrument?
Paris.
Paris. So here, Paris, the plaintiff, made a prima facie case, and prima facie means on its face, right? He made a prima facie case by producing the paper in court and establishing that Helen, the defendant, had signed it. Because he's holding what? A note that says, I, Helen, promise to pay you what? $10,000 in 6 months at 2% interest rate to Paris. So here, what happens here is it is not necessary that Paris prove that the note had been issued for consideration. However, in order to enforce the note in court, he has to establish he's the holder of the paper or an assignee. And here, he's actually shown the court that he is what? Here's the note. She wrote it to me, and she signed it, and she admitted that she what?
Oh,
Signed it. Her argument was, but you also have to show that you gave what for it? The consideration. And they said, no, you made the prima facie because you had what? The note. There. He has no difficulty here because the note was issued to him as the payee. He had possession of the note. Helen would have the burden of proving the evidence of the defense against Paris's right to recover on the note there. So really it shifted to her then the burden because he at least had it to show, look, you gave me this. Let's look at another one. Okay. McDreamy draws a check. So he drew a check. The payee endorsed it to Medical Supplies Company. So he draws a check. I'm just going to put the payee here. Because that's who he wrote the check for. The payee endorses it, and what do they do with the check? They endorse it to Medical Supplies Company. Or sales, sorry. Medical Supply Sales. McDreamy then stops payment on the check. So he gives a check to the payee. So who do you guys want to throw in here? I'm trying to think. We'll do Meredith before they were married. If that helps you guys, right? He writes a check to Meredith. Meredith then turns around and endorses the check and gives it to who? Medical Supply Sales. What does he do at the same time though? He now puts a stop payment on the check on the grounds that there was a failure of consideration for the check. Medical supply sales turns around now and sues McDreamy because she took this check, endorses it over here. During this process, while this is going on, he goes and puts a stop payment on, and they now have already received what? They don't know that this is out there yet or anything, right? And now all of a sudden they go to get the money and they're not told what, probably.
They can't get
We're not paying you. They turn around and sue him. Okay, on the check. When McDreamy raises the defense of failure of consideration, medical supply sales replies it was a holder in due course. He claims that they could not recover because McDreamy learned of the defense before medical supply sales deposited the check in its bank account. What we want to do is discuss the parties' arguments and rights in this situation. And you guys can even talk to your classmates. I'll give you guys a few minutes to think about it. I will repeat the facts, though, to help you guys. Because I want you guys to see what you can come up with. McDreamy drew a check. The payee endorsed it to medical sales supplies. McDreamy then steps payment on the check on the grounds that there was a failure of consideration for the check. Medical supply sales sues McDreamy on the check. When McDreamy raises the defense of failure of consideration, medical supply sales replies it was a holder in due course. So they're claiming, hey, we're HGCs. She was probably what? You get where we're going? Okay. McDreamy claims that medical supply sales could not recover because McDreamy learned of the defense before medical supply sales deposited the check in its bank account. And you have to discuss the parties' arguments and the rights in this situation. So take a few minutes to figure out what you think.
So wait, why did McDreamy give Meredith the check in the first place?
It's just a lot of times we might not give you all the details. They're drawing something to check. It could be, here's your money, I bought goods.
Okay.
Do you get where we're going?
Yeah, but because he said the failed for consideration, so like I want to know, did she
He's
not
saying
come through
that-
on it?
Well, and it could be, hey, I gave you this check. They're raising the defense here. He put the stop payment, and he's saying you can't come after me because there was failure of consideration.
Okay.
And by the way, I change names. I'll tell you these are all in the back of your textbook, so I'll figure out what problems they go to so you guys can go back to them and look. Because I do pull some of these from the checkbook, from the textbook. But take a few minutes. You can talk to your colleagues. Figure out, do you think they're correct? Do you think they're correct? He's correct.
Like based on like to me like they thought they received the check in good faith with no knowledge of the absence. Medical supply sales and their holders, of course, they have no clue anything that's happened previously in terms of what the only thing that I'm like confused about is wondering how they add value to what the promise, whether you have to go through a promissory check. Yeah, if there's value.
This one I know I got from somewhere else. I don't see it right now. This one was problem 3 of your textbook, in case you guys want to go back and look at that one.
I'll have to go back.
McDreamy said that he stopped the check before it even got to them, right?
McDreamy stopped payment, but he's claiming that, so his defense, he's going to claim as his defense to try and go against. He's saying I'm a holder in due course. Holder in due course is, this is where it goes back to, remember we said there's limited defenses and universal defenses. He's claiming that, hey, but there was lack of consideration and therefore I can raise that defense against you as a whole HDC.
I just don't understand what lack of consideration. I don't.
Well, it's one of the arguments because when you get to contract rights, you might say there's lack of consideration, lack of value, things like that as defenses to negate a contract.
So then
He's trying to claim that, which gets into, we'll get into the defenses shortly too. But yeah, he's trying to say that, but you're not a HDC because I had this defense.
Okay.
I'm making you guys think right now a
Yeah.
few things. I'm taking you outside the box on, but we're doing this. What do you guys think? What do you think the arguments? Each of the parties' arguments. What do you think? Who do you think is going to win? Who?
Supply company.
And why?
I feel like he had nothing to do with what McDreamy and Meredith was going to do. So I think McDreamy's going to have to pay the supply company, and maybe McDreamy can sue Meredith for the money that he had to pay.
Okay. What was your thought? Same, different? You had to look like?
Yeah, I thought the supply company would win also because McDreamy, since he was supposed to be paying on that check, even though it was supposed to go to Meredith, but since she had to give the supply company the money, he was still supposed to pay on the check because that's what he's been doing,
Okay.
basically.
I get what you're saying. He's still obligated because he had to pay on the check anyways, whoever had it, you're saying.
Yeah.
I get exactly what your theory is going there.
I feel like because
You are who, just really fast? Tiffany? Okay.
I feel like because Meredith was a holder, she could do like anything she wants with the check because he had to pay her anyway. So I feel like because she gave it to the supply company, it was not his problem at all.
Okay.
Like that, because she can do whatever she wants with the check once
Okay.
she has it.
Any other? James?
Medical supply, what you've said meets all the criteria of a holder in due course. He says that he has a defense, but they had no knowledge of that defense. It seems pretty straightforward to me.
Yeah, I would agree with that because like the supply sales company has no clue of what happens between the first two parties, and obviously it seems like they're operating in good faith, and so that, just by process of elimination meets the process of holder in due course, or the steps or requirements.
Any other thoughts? You guys you're getting there. Because, medical supply sales was a holder in due course entitled to recover on the check. Medical supply sales did not acquire knowledge of the defenses until after it had acquired the instrument. So it didn't know of any of these defenses up until this. When it got it, based on, because I didn't throw a lot out there, but based on what you guys could see, they didn't have any knowledge if there was wrongdoing or not. They just know this check got endorsed to them, right? Even though medical supplies had not yet deposited the check when it learned of the defenses, that's not controlling and determining whether or not it had HDC. The fact is, at the time it got the check, it had no knowledge of any wrongdoing. It's different, though, had medical supplies, they knew of that defense before, right? That maybe something was wrong up here. But if they don't have anything or they're not aware of it, do you know what I mean? As long as it's on good faith and all that type of stuff, and they got some sort of value for it, and no knowledge of this, and you meet this, you're going to be an HDC. There are two different types of defenses, because I kind of raised the defense in this situation here, right? Lack of consideration and that. Let's talk about the two types of defenses. We have limited defenses and universal defenses. So it's important to realize the distinction between the two. When we say limited, what we mean is that there are certain defenses are limited to what a defendant may raise against a HDC, a holder in due course, or a holder through a holder in due course, or things like that. So when we look at your textbook, and I will pull out the chart 565 here for a minute, if you look, you will see universal defenses column, you will see limited defenses, and then they'll have a mixed. And this says the circumstances can vary the availability of those defenses in those two situations. Now, this is different when we discuss universal, because universal defenses can be asserted against any party. It's available against assignees, holders, and holders in due course. These are real defenses. So if you have fraud as to the nature of the instrument, which is fraud in factum, okay, that's different than fraud and inducement. Fraud and inducement is a limited defense type thing there. But if you look at these things, fraud is the nature of the instrument, forgery, unauthorized signature, incapacity, illegality, alteration, consumer credit contracts, they're telling you those are universal defenses, and those are available against all parties, right? We can raise that against all parties. But the limited, those are available against assignees and holders, but we cannot raise these against HDCs because they get special what? Rights. So you have limited defenses. So if the party's an HDC, you're limited on what you can raise. Do you see where we're going? Versus the other ones. And that's where it gets tricky. Now, I'm going to tell you guys right now, for exam purposes, I usually just say, understand there's universal, there's limited, and know which one is which. You know, to kind of give you guys an idea. I try not to be too tricky on all that. It's really, can you figure out what are the two types of defenses and which category falls in which, to know what is an example of each there. Let's talk about the party's liabilities when we're dealing with negotiable instruments. Because the holder in due course, where do you have to turn first? Because what we have to know is whether it's Meredith or whether it's medical supply, who do you go against first? Who's going to be liable on this check? Do you see where we're going? Whether you're a holder in due course, who do you turn to get your money? And when we talk about this, we say you have to first turn to the primary party for payment. Well, it depends on what we're dealing with, because if we're dealing with a check, we know a check involves how many people? 3 parties, right? Because we said there's two types of papers when we talk about. Remember, we had the order papers. Well, there's paid the order and then the beer, but we had the promissory notes and CDs.
Oh.
Do you get where we're going?
Yeah.
So you had promissory notes and CDs, and then we had what? Drafts and checks. And this is why you had to know who the parties were, because this had 2 parties, this had 3 parties, right?
Yeah.
So here you only have what? A maker and a payee. Here we had a drawer, a drawee, and a payee. Well, if we only have a maker and a payee and we're dealing with a promissory note, who's our promissory party that the payee has to go after?
Maker.
The maker. Do you see where we're going? When we have a check, usually who do we go to first? Usually the drawee is who? A bank. You take the check, you present it to the bank for what?
The money.
Payment, for presentment. So that's why we said if you know the parties. So if it's a note or certificate, the primary party is your maker. If the negotiable instrument is a draft, your primary party is the drawee. If it's the bank is not primarily liable on a check, however, because the bank has the right to refuse to pay. Because if they realize that maybe a person doesn't have enough funds or something like that, because maybe they know their account's there. Do you get where we're going? If it's a draft, we said you go to the drawee. But if it's bank, don't forget, you can go to them first, but they don't necessarily, next chapter we'll learn they can refuse payment on checks. Or maybe they can refuse because what did they get notice of? Stop payment, right? Or something like that. So that's the one thing there. But usually, who are you going to go to first here? The drawee. If you're dealing with these, usually you will go to the drawee first. If you're dealing with these, you're usually going to go to the maker. You guys with me so far on all that? Okay. If the holder cannot recover then from the primary party, then the holder has to turn to the secondary party or the secondary obligor for payment. Secondary parties on notes are going to be who's the endorser then. And secondary parties on checks and drafts are going to be the drawers and the endorsers. The endorser is who wrote it. Again, it's the maker here. So you're kind of stuck with either what? Whoever was the maker of the promissory note or the endorser. Here, though, if this guy's not paying, the drawee, let's say the bank refuses to pay, who do I go back to then? Who's my secondary? Well, who wrote the note? The drawer. Who owns the account? You're still what? Liable to me because your bank refused to pay me. And you still owe me that $650 or whatever we want to throw in there, $1,000, whatever. What is presentment? Presentment is where the holder through a holder in due course makes a formal request for payment on that negotiable instrument. So once I take that negotiable instrument, whether it's the promissory note, whether this is a check, and I go, here you go, please pay me, right? And I make presentment, that's what I'm asking for. So we get into that. I can take my check back for now. One day I'm going to come in here with little fake checks, so when I play around, right, and promissory notes, I always turn that into it. If the primary party refuses, though, to pay on the instrument, then we have what is known as a dishonor. So when that bank refuses to pay, because maybe all of a sudden they tell you we're not going to honor it because maybe our person did not have sufficient funds or something like that, so we didn't pay the check and then it gets sent back to you and you get charged fees. We'll get all of that there. That's a dishonor, and the holder should then turn to the secondary party. Hey, your bank didn't pay me, I'm coming after you because you still owe me. You might ask for cash at that moment too or something, because you might not want another check then, because you might fear that that check will also what? Be refused payment. What's a dishonor? It's when the primary party refuses to pay the negotiable instrument according to its terms. Now, the primary party, we said, had to give notice of dishonor. The notice of dishonorment can either be done orally, so verbally, I tell you, the oral, or it can be in writing, or it can be electronic. The notice of dishonor is subject to a time limitation, so the holder must then turn to the secondary party for payment upon the dishonor, and then the secondary party may pay according to the terms of the instrument. The secondary party does have limited defenses if the presenting party is a holder in due course. So that's where the defenses come in on what can you raise against that person if you're going to say, well, I don't have to pay. If they're a holder in due course, you're going to have limited defenses. Yeah.
When the original holder deposits the check into their bank account, does the bank become a holder in due course?
The banks usually, because they're the drawee, and they put it, you're talking about,
The holder's bank account.
like if Meredith,
If Meredith deposits that check into her bank account, does her bank become a holder in due course?
when you get into banking, and we don't get into it in this class too, because if you start involving other banks, you start getting like payer bank, payee bank. Do you get what I mean?
Right.
And then like out of the accounts, and it starts getting into that. Like she has it. They're honoring because they have your money. They're usually your bank. You're drawing on yours to get where we're going onto the thing. And then what'll happen is usually the other bank might go after that bank and say, hey, we paid off,
Right.
but you didn't now because they didn't have money. And you start getting into like sometimes the banking. I don't get into that, and we don't get into it in this textbook. I know I did it in law school. Like we had payer banks, payee banks on top of all these other parties. You know, because sometimes you might have multiple banks in the middle there, if you get where I'm going. And I'm not going to go that far on you guys on testing, and don't. Yeah. I don't know if that fully answered your question, but it's going, no, not really.
Well, the reason I'm asking is going back to the car problem you put up last week.
Yeah, we're going to come back to it because I'm going to throw it up. And yes, can they be, like, depending on who the parties are, they can turn into holder in due course.
Okay.
Yes, if they are giving value, and yeah.
Okay.
Does that kind of go? Answer, yes, you can turn into things.
Okay.
You can turn into holders in due courses. And yeah.
Got it.
Yeah. See, he's thinking ahead. He goes, wait a minute now. I'm starting to rethink what we did last week. And when those facts go back up, I'm going to give you guys time to reread it to see if things change, you know, after this. Let's do the following situation. Let me erase this for a minute. And let me pull blacks. It's kind of getting a little ugly on this board. Okay. All right. We have Al Capone. Al Capone issues a negotiable promissory note to his attorney. Right? I promise to pay you money, blah, 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 percentage. Okay. In return for the attorney's promise to perform legal services. Right? He promises to pay him in return that he will do legal services. The attorney never renders the services, but he quickly negotiates the note to Bonnie, a holder in due course. So he takes this note, that note, right, this note, and he negotiates it further to Bonnie, who's a holder in due course. So I'm telling you, she gave what? Value, good faith, all those type of things there. Bonnie and Clyde were involved in business negotiations, and Bonnie offered to purchase the car from Clyde. She offered as part payment for the car the note that was issued by Capone, because she acquired this note from who? The attorney. Are you guys with me so far? So Bonnie and Clyde are involved in business negotiations. She offers he's going to give her a car. She offers to give him part of that negotiable promissory note. You see where we're going? As part of the payment. Okay. By coincidence, when he gets this note, Clyde knew both Capone and he knows the attorney. And he knows the facts concerning the note and the unperformed legal services. So if she purchases the car and as part of the payment, she gives him that negotiable promissory note. Okay, and he's aware of these parties and he's aware of this. Despite this, Clyde accepts the negotiation of the note from Bonnie. He now goes to collect what, do you think? On the note. From who? From Capone. But Capone refuses to pay the note, and Clyde eventually sues Capone to collect. What do you think the probable outcome is? So he now comes here to collect. A refuses, and C sues. You are who again?
Me?
I know you. I just am drawing a blank.
Brianna.
Thank you. I'm like, I knew your name.
I think Al will win because didn't the attorney not do what he needed to do to actually get the promissory note, you said?
So you're going with Al's going to prevail on this because the attorney never performed services.
Yeah.
Okay? I'm not going to answer yet one word because I'm going to let the class keep going too. I will tell a final outcome, don't worry.
Okay.
Does everybody agree? Yes, yes. Anybody disagree? So Al gives the promissory note to the attorney for performance for legal services that the attorney never ends up performing, but the attorney took that note right away and negotiated it further to Bonnie. Bonnie then uses that note and gives it to Clyde. Clyde is aware of all this. Start identifying the parties. Who's what? What is Bonnie?
Bonnie's a holder in due course.
Right, because the attorney was what?
Yes,
A holder. Right? Well, he negotiated it, so holder.
Oh, so it wasn't.
But you guys said she's what?
Holder in due
She's a
course.
holder in due course. Does she know of any wrongdoing?
No.
No. Does he know of any wrongdoing?
Yes.
Can he be a holder in due course?
No.
Can he be a holder through a holder in due course?
Yeah.
Okay. So now we know why he's suing, because he's a holder through a holder in due course, where that famous comes in, right? So let me ask this then. If he qualifies as a holder through a holder in due course, is he entitled to collect? What defenses can Capone raise against him then, if he's a holder through a holder in due course?
Couldn't he raise the defense that he has the rights as a holder to, like, he's not a holder in due course, so he doesn't have those special given rights of a holder in due course. But, like, a holder has every legal capacity to, like, collect on this money. So couldn't he?
But holders also universal defenses, remember? Because we said universal defenses are available against assignees, holders, and holders in due course. Where limited defenses are available against assignees and holders, but not against holders in due course. And if we said the shelter rule, right, a holder through a holder in due course acquires what? That shelter rule, even though he knew it wrong. But the question is Al liable to pay on that note? To Clyde. If Bonnie would have went to him, should he have paid on the note?
Yes.
So could Clyde get the note? Because even if Capone hypothetically has to pay on the note, does Capone have something he can do? What was Brianna saying? What?
Sue the attorney because the attorney never did the services for the promissory note.
There you go. Do you get where we're going?
Yeah.
So what'll happen, and think about this for a minute, and we'll come back to Capone, but think about this. Imagine I write you a check. You then negotiate the check to Abel, who then negotiates the check to Beth, who then negotiates the check to Kathy. When Kathy wants to get paid, she cashes a check that has whose name on it? Who drew the check? Me. Who's liable? Because we said if you can't get it from the party before you, you go to who eventually? The endorser, the maker, right? The drawer, the maker. Thing. Am I still liable on the payment of this check? Yeah. I'm still going to be liable because the money would come from my bank account, but if the check's been canceled or the bank account's closed, she could still sue me because it's whose check?
Yours.
My check. Even though it was negotiated further, she's expecting to get what? We're assuming also that they're all what? Holder in due course is holder. Do you get where I'm going? A holder through a holder in due course. There's no wrongdoing or anything from the initial person, right? We got that. So here, if we get to it, she can sue other people on the line if there were specific issues that they should have but failed to tell her. But at the end of the day, though, it's whose check? My check, right? The drawer. Be careful. Check is drawer. Maker is promissory note and CDs.
Okay.
Just, do you know what I mean? So when you
Yeah.
identify, because there are questions that I'll ask you to identify.
Yeah.
So I just want to make sure. Yeah. So what happened, though, it's still my check. At the end of the day, it's my check. It was written by me on my account. And when she sued me, what'll happen is I can countersue some of the other people maybe that negotiated my check. Do you see where we're going? Because maybe they got money for that check or whatever it was, or do you get where I'm going? But if she comes after me, my recourse might be after somebody else. So if we do this one, it's the same thing. Clyde might win here, and yes, Clyde may have known about the issue here, but guess what? He acquired rights from who? Bonnie was an HDC, so he became a holder through a HDC. He's going to get his money from Al. Al's going to have to turn around and sue who? The attorney who failed to do the services. Which your thinking was, you were there, you just had to say, instead of Al winning, Al's going to lose against who? Clyde, but Al's going to go after you for failing to perform. So you had the right reasoning, you just had to sue the other party. Do you get where I'm going? Like you had it there, you just had to, he'll win, but he's going to go after now him.
Okay.
Because I still had to pay on this note then who had it, but because you never performed my services, you're in breach of what? This in a sense. You know, you didn't do the services that I gave you the note for. Are we good so far? Everybody, okay. Let's look at the example in our textbook. Thinking things through, the check corner cashing company and thieves. Who wins? And if somebody needs to borrow my book, you guys can, because I want you guys can draw it out. I want you guys to take a few minutes and actually work on this one. So does somebody need a book to borrow?
What page is that on?
It is on page 567.
Okay.
And it's the purple box, the thinking things through. And I did start doing the assignment sheet. That is funny.
Right.
See, we got brought into the box. Okay. Like I said, after you guys had a few minutes, you guys have read it, digested, talk to your colleagues, because we will come to an answer in this, but I want you guys to try and work it out. And hopefully as you guys are doing this, you're realizing we're pulling together all the chapters 27, 28, and 29. So really everything we've discussed in these three should be brought together in this fact pattern that you guys are looking at.
Did you sign it? Thank you.
I think that is all, every 14. And that's everybody. Cool. Thank you. Thanks for your Don't be shy. When you guys are done reading, go ahead and talk with your neighbors. If you guys have to draw it out, draw it out. Sometimes it helps when you draw, like, to see who's getting what and where. Gotta add him in, right?
Yeah. Said would CCC be a holder in due course? Because wouldn't the first whatever their name, the first bank, wouldn't they be a holder and then if they
I think I diagrammed it pretty good for you guys, if you can understand it. No?
Oh no, I'm just the whole situation is confusing me.
Are we to assume that the check cashing company took the check with absolutely nothing on the endorsement line? Or are we to assume that the thief forged an endorsement?
Well, the thief probably, what?
I would have forged an endorsement if I stole the check.
Well, and I told you it was an unendorsed check when he sold it.
Right.
So, yeah, I mean, you gotta kind of fill in here. But the whole thing is, are you able to help First Commerce Bank do a response to them? And then the next question says, suppose he had already endorsed the check when it was stolen. So the first one is, it's unendorsed, right? Then they'll say, switch it and say, what if it were endorsed and now he stole it? Does that make a difference in your outcome?
Right. And that's why I'm wondering in the first scenario, because I think it makes a difference if the check cashing company took the check and an endorsement had been forged. I think that they took it in good faith. But I think if they accepted a check with nothing on the endorsement line, I think that's bad faith. You see what I'm saying?
Well, let me ask this though. Even if they took a check with an endorsement, could they maybe have some responsibility to make sure the person who signed it is the person that the check is written to?
Yeah, that's what I think.
does your answer differ in one way or the other, or do you think both ways? Like, what would you argue for them to help them when they come now for payment and they don't pay?
Yeah, so I think in the event the check was endorsed, like, the bank should be held liable because, like, you have to do your due diligence, and if I came to the bank with a check that was, you know, endorsed as it was, I would still check for ID because, like, if you go to the bank with anything, they're like, you know, we need to see ID, and so I don't think the bank would be operating in good faith if after they went through their policy of checking for identification.
Go ahead.
So Fred didn't sign the check.
So when he stole, the thief came along and stole it, he stole all the cash and the unendorsed check from Sid, yeah. So he had
So
it
the thief could have signed it.
as who?
That's
As
Fred.
As Fred.
That's not like the check cashing company keeps a big record on file of the official signatures of everyone who writes checks in the world. I mean, as long as the endorsement line looks something like Fred, I think if they accepted a check with nothing on the endorsement line, or like someone drew a tree or something on the endorsement line, then they, you know, the bank has a defense there. But if the endorsement line looks something like Fred, whether it's genuine or not, they accepted it in good faith.
So who do you think wins overall between these two?
Well, that's what I'm asking. I mean, it makes a difference if
So in the first one,
if they
If-
accepted a check with absolutely nothing on the endorsement
Mhm.
line, then I think the bank wins. If they accepted a
when
check,
you say that, you're saying FCB, right?
yes.
Okay, I just want to make sure I got the, oh, because I accidentally wrote bank here. I should have said cashing company, huh? So bank, cashing company. There we go. Okay, that was my fault. I wrote bank.
I think if the thief forged an endorsement that looks any kind of genuine, then I think the cashing company wins.
Go ahead, David.
But wouldn't they have to ask for ID even if he signed it as Fred?
No, because you don't have to show the idea. Like if it's endorsed over to you, right?
Mm-hmm.
So if it's endorsed by Fred over to whoever, whatever your name is,
Mm-hmm.
you don't have to show the ID of the person who endorsed it to you.
You have to show your ID.
Yeah.
Right, but
To
if-
show that they
if-
wrote it out to you.
Yeah.
If you forge an endorsement to yourself, which you can transfer a check. That's what this whole day has been about. If you endorse the check to yourself and forge Fred's signature to endorse the check to yourself, you show your ID. You are the person that the check has been endorsed to, and that's the end of it.
Would it make a difference? Let me throw one more kink in here, because you were asking the endorsement there on the front if it just had paid to the order of and nothing.
Yeah, because then the thief forges their own name in there. Then they don't even have to forge an
Well,
endorsement on the
and
back.
do you guys understand why I asked him that question? I mean, because was it an order paper or bear
Yeah,
paper?
that's what-
Do you get where I'm going? Because it had nobody written down there.
'Cause
He could have just as easily wrote pay to the order of cash, and
Right.
that's why I just was curious. Would that even change your outcome?
I got that right.
So does everybody kind of see? I mean, but that made sense. You guys understand what we're doing here? Here, you know, my question would have been, what would you conclude? Who do you think won? You guys have been giving me. Here's the outcome. On a forged instrument, the CCC bears liability for not verifying the customer's ID and endorsement. If the endorsement was on the check and in blank, then it was bear paper, but CCC should still check ID transaction sale rules. On order paper, it's the first party to take the instrument after endorsement because it had the same chance to verify. There. So, you know, and you try, and the whole goal was, could you make arguments for each? Could you try? Because sometimes it comes down to, were you a holder in due course? Were you a holder? Do you know what I mean? You know, and then you get into, sometimes, you know, who bears the most responsibility then? Who bears it because he gave a thing, if it was all written out to him, but then he never signed the back, but now he forged that instrument. Do you know what I mean? Was he negligent in where he put it? Do you get where we're going? You know, did you leave the check out in the open that someone easily could have just what? Grabbed it? Or was it in a locked box where maybe you weren't as negligent? And, you know, so you do get into those type of things there. Yeah.
What was the outcome for both?
It was on a forged endorsement, okay, on a forged endorsement, CCC bears liability for not verifying customer's ID and endorsement. If the endorsement is on the check and in blank, then it's bear paper, but CCC, they said, should still check ID, just according to the ID transaction rules. Do you know what I mean? So bear paper, you have a little bit of things there. On order paper, it's the first party to take the instrument after endorsement because it had the chance to verify.
So if, like he was saying, how if he forged Fred's signature and then he just can't you give it to write it so you are giving the check to someone else on the back of the check?
You can do the bear. Now I will tell you, some people give you issues on that though, where sometimes banks might. Mm-hmm. Yes, you can do that, but sometimes banks are. No, we don't want to accept this because maybe that liability, because don't forget, sometimes it falls back on the bank then, and they might refuse then to pay because they're not sure. Maybe they might see suspect of something like that, is this a stolen check where maybe they just signed the back and did this and paid to it? No, we'd rather have it there. And I had that happen to me once before. I wrote a check to somebody, it was candlelight. You know, I went to a candlelight party, I wrote a check to the person who held the party. She didn't realize that the rep said, no, have her write it to me. Well, I had already written out to her, given her the check. So I said to her on the back, I said, oh, just go ahead and sign it, endorse it, and pay it to, move it forward, negotiate further. And it was funny because her bank actually gave the rep, I think, a hard time. Didn't want to honor it. And she goes, can you do me a favor and just rewrite a check for the rep? Or I think she just had me rewrite her one or two. Do you know what I mean? Just to take out that middle because they gave a hard time on it. Yeah.
So I understand that no check cashing company is actually going to accept this because of what you just described. But what you're saying is, if the thief had taken the check, it was blank on the endorsement line, and wrote down endorse from Fred to thief, and the check cashing company does accept it, then the check cashing company is then a holder in due course. Yes?
Yeah, well, what they're saying on the order paper, it is if it's bearer paper, they're saying you should still check ID, but just to ID rules. But yes, you're coming, if it was on check and in blank, they're probably going to say you're the holder.
What I'm saying is, if the forged endorsement is Fred endorses to thief, mm-hmm. and then so then because it's endorsed to the thief, the check cashing company is not going to be asking for Fred's ID because Fred has endorsed it over. Yes. Mm-hmm. And so then the check cashing company is a holder in due course if there's a forged endorsement for the thief. That's
and I don't have my book really fast. Yeah, but the thief, thank you. The thief though is not a holder in due course because they did wrongdoing.
Right.
Do you get where I'm going? So they didn't acquire it from a holder in due course because that person did wrongdoing.
Okay.
Do you know what I mean? So you start getting into that too because it's for, and then this is where you get into the other thing too, probably your defenses. Do you remember? Because you know how certain defenses if you could raise.
Right.
And all that. So depending on what it was, remember Universal is the forgery, all that type of stuff can come in. Yeah. That's where, can I raise any defenses on why I shouldn't have to pay? Okay. And that's where it might come into here. I gave you this check. Yes, I'm the drawer. Yes, I'm responsible because maybe he already had the goods, which it always usually falls back on who? You're the drawer. So even if say it ends up coming to him and he has to pay, right? Or something like that on that check, it might not be there. But the whole thing is, even if, say, hypothetically, he ended up having to pay him for the share or something like that, you always go back. Were you maybe negligent? Do you know what I'm saying?
Got it.
I mean, you still have to pay on that, but sometimes it comes out to
Okay.
on that thing. But usually it always says, you still wrote the check, you're still liable. It's just, then do you sue the people in the line?
Got it.
Kind of going back to Capone. Do you remember? It was still his check. He just didn't get what? His services. He still had to pay to Clyde, but then you go through that.
Got it.
And it can get very, ugly in these? It can get messy. And the whole thing is, are you guys realizing one thing? Why we do holder in due course? Why in commercial transactions, when you purchase goods and we're in contracts and we always say the bona fide purchaser, you're always trying to protect who then? These people out here, because they sometimes don't know. So sometimes that's why these parties will win out over what? These parties. Because we sometimes say, let's protect that innocent purchaser who paid value for something, had no knowledge of any wrongdoing. You know, they got this instrument, they didn't know what was going on. Let's make them a holder and give them greater rights. Yeah. Which now takes us back to, remember you were starting to think? I'll let you guys reread this one. And we'll see if your guys' thoughts change. And I'm just going to ask one more time. I just want to make sure everybody was here last class, got the handouts. Anybody not here? That's why I want to ask, because at the beginning of class, sometimes you guys may not be in the room when I ask if I walked in. That is what's due on exam day. So that's like each chapter of questions, and then we do like for each chapter, kind of like true, false, multiple choice questions, like as you're reading.
Is it the next Wednesday after Martin Luther King Day? That exam? Or is it on Monday?
I think it's the Monday, so we have to do exam review.
It's on our syllabus, right?
Yeah. I think it's Monday. Because we're going to review for exam on the 22nd, and that's when homework's due.
Right, okay, gotcha.
Yeah.
I see it. Thank you.
So that Wednesday when we come from Martin Luther King, we'll review for exam.
So that's the only homework due besides our reading that we've been doing?
Mhm.
Okay, thank you.
Who was my other one? Valley and Automotive Red, Arizona. Has everybody read it? What do you guys think? Does your answer change? I know last time the whole class said what?
I think we all said 3.
You guys all said, didn't you say Arizona you went for? Yeah, you guys, everybody. Does everybody still agree? Does everybody still think Arizona prevails in the lawsuit?
No.
You say no? So you're going to Valley?
Yeah.
Why do you think Valley?
Because they wasn't aware of the fraud, so Arizona still has to make payment on that check to Valley.
And what would Valley be?
A holder in due process.
Due course.
Due course, I mean.
That's okay. There is due process too, but I knew where you were going. Does everybody agree? Yeah, James?
I don't think Valley National's a holder in due course because of, I think 1 and 3 don't matter, but number 2 kills the case. They were careless in allowing Central Motors to withdraw the funds without letting the check clear on the bank on which it was written. I think that's the important part there. There's no good faith because they broke, I don't know if this is a law, but at a minimum it's an industry standard. Check from another bank, you gotta wait a couple days to get the money, and they allowed the money to be withdrawn right away. So I think that the Valley National is still.
You say Arizona, you think Arizona's still gonna win?
Yes, the Valley National is not a holder in due course because they did not have good faith.
Okay. So you guys have 2 arguments so far. One's for Valley with Tanisha, and one's against Valley with James. So how many agree with Tanisha and think Valley? How many agree with James still and think Arizona? You have 1, 2, 3, I see so far. 4. Or wait. I think.
Yes.
Okay. Then I wasn't sure if it was putting the jacket on. That's okay. That's why I was like, oh wait. So 1, 2, 3, 4. What I
It
said.
could be Arizona.
You're going with Arizona?
Yeah.
So 5 and did I say you had 1, Tanisha, with you? I think you had. Did 1 say Valley? Or is it just Tanisha so far? Maybe my 1 was just you so far. So far I'm 5 and 1. How many feel more confused?
Yes.
So you guys ready for the result? Valley was a holder in due course. Valley prevailed. The other thing I was thinking is, remember the one time too though, where we had the one situation with McDream, was it McDreamy, and we said it didn't matter where, as long as at the time they took it, they were a holder in due course, you know what I mean? Took it in good faith at the time, it didn't matter if you learn about it after or anything. Yeah, usually they do wait 2 days for transfer. Sometimes though, if it's an account to an account, they'll do it the same day, or if they know your funds are in there. Because sometimes they'll say your funds will cover if that one bounces. Do you know what I mean? And then they'll just take it back or whatever.
So you said Valley won?
Yeah, Valley prevailed in that one.
Why?
Because they were a holder in due course. And by the way, these I did not make up. These are actual things that I'm pulling for you guys so you can see outcomes of those. And that's why I kind of held off coming into today. Now you understand why I waited one more day to let you guys see, hey, do you think this would change? But they ended up prevailing because they were a holder in due course is what they were found to be. Any questions on any of this so far? My next question for you guys is, has everybody started working on these, the multiple choice true false? Does everybody have the first couple done, or does anybody still need to work on them? You need to work? Then what I'll do is I'll hold off one more day. If you haven't worked on them, work on them. No, we're going to go over them in class.
Okay.
That way you're not just coming in, sitting and getting all the, you know what I mean? I'd rather you guys try them. You will get the correct answers, trust me. If we don't get them by next class, like my goal next class is if we get done with more time like this, we'll go through them all. I'll give the answers. If not, by review day, you'll definitely get them before the exam.
The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you.